Don't forget to subscribe to our Telegram channel for all the updates and materials.
Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper analysis from the perspective of civil services examination. Today we have taken up Delhi edition of The Hindu newspaper dated 7th of October 2022. The articles that we shall cover today have been displayed on the screen, and let us now begin the discussion.
So the first topic for today's discussion has appeared on page number 3 in Delhi edition. And it deals with the administration of Delhi. In one instance, Kejriwal writes to Lieutenant Governor, asks him to chill. And the second instance, look into non-payment of bills by Delhi government has been stated by Lieutenant Governor. Now the control over Delhi, which is a union territory according to the Constitution of India, but with elected legislature and council of ministers headed by a chief minister, has always been a problematic legal issue, especially when it is headed by different parties in the center in the union territory. Now, the 2018 judgment of the Supreme Court was very important in this matter. At least it temporarily settled the matter between center and union territory of Delhi, where a constitution bench had unanimously held that Lieutenant Governor of Delhi was bound by the aid and advice of popularly elected government headed by Chief Minister. At the same time, the 2018 judgment had made it clear that the powers of center and the Delhi government were collective and coextensive. And so 4 years down the line, these two parties are again fighting, and so this matter has again been referred to the constitution bench. And so in this discussion, we are going to understand the evolution of administration and its arrangement in Delhi through time. Then we are going to look at the constitutional provisions with respect to Delhi and what did the judgment of the Supreme Court say in 2018, because of which Government of India brought an amendment to the Act in 2021, and what are the issues. Let's now begin the discussion. Okay, so Delhi as we know it today has not existed like this in terms of administration since the time of independence. Delhi became a Part C state, you know those categorizations of A, B, C and D, in 1950. Then in 1951, for a very brief period of time, Legislative Assembly was created with an elected CM. But that lasted only for 5 years, because all of us know that in 1956, States Reorganization Act reorganized the whole country, and in that process, Delhi became a union territory to be administered by an administrator who was appointed by President. And so, Delhi began to be directly administered by the central government, and this continued for a very long time. Although some form of representative local government was provided to Delhi in 1966 in form of Delhi Administration Act 1966, which provided limited representative government through creation of metropolitan councils. That has continued even now. And so, finally the current arrangement started in 1991 when 69th Constitutional Amendment Act, which was based upon Balakrishnan Committee report, again created representative form of government in Delhi through creation of Legislative Assembly and Council of Ministers to aid and advise the Lieutenant Governor. So what is the constitutional scheme of Delhi? We know that various parts of the Constitution of India deal with various aspects of administration of the country. So for example, Part 5 deals with the union, Part 6 deals with the states, deals with the union territories, and as you can see, Article 239AA, Article 239AA carries special provisions with respect to Delhi. And so, there should not be any particular doubt in your mind whether Delhi is a state or a union territory. Delhi is a union territory with Legislative Assembly and with elected council of members to aid and advise the Lieutenant Governor, just like Pondicherry. Whereas all other union territories do not have an elected council of minister headed by a chief minister, and they do not have a legislative assembly as well. So what are the provisions of Article 239AA, which was inserted through 69th Constitutional Amendment? So first and foremost, it granted special status to Delhi. Why was it special? Why is it called a special status? It is called a special status because despite being a union territory which is supposed to be directly administered by the central government, it was provided with Legislative Assembly and Council of Ministers. And just like legislative assemblies of all the states are empowered to make laws on state list matters and concurrent list matters, even the Legislative Assembly of Delhi was empowered to do so, except on three important matters: public order, police and land. And this has been the root cause of the problem between the Delhi government and the central government. Because whenever a party comes to power in Delhi which is different from the party commanding the power in the central government, it always leads to conflict, because public order, police and land are one of the key and important aspects of governance. If a state government does not have police under their hands or the land under their hands, they will not be able to fulfill a lot of needs of the local residents. And that is where, when the confrontation first emerged, when the Aam Aadmi Party came into power in Delhi, they went to the Supreme Court and Supreme Court decided the matter. And Supreme Court came up with its judgment of Government of NCT versus Union of India 2018, in which the Supreme Court first and foremost ruled that since Delhi was a union territory, all powers lay ultimately with the central government and not the elected government of Delhi. And so it was a big boost to the claim by the central government, because after all, this is what central government had been saying past many years. But there were other aspects to the judgment as well, which is very relevant for us to be understood. So apart from reinstating the claim of the central government, Supreme Court observed many things, and it issued a form of principles in order to ensure the better governance and efficient administration of the Delhi. It said that Delhi government has powers in all matters except public order, police and land. And so the LG would be, or the Lieutenant Governor of Delhi would be, bound by the aid and advice of Council of Ministers just like all other governors, except on those matters which are mentioned in the public order, police and land. So if the government comes up with some initiative in health and education, the Lieutenant Governor should have no problem and should usually approve that initiative. But if an initiative or a law deals with police or land, Legislative Assembly and Council of Ministers cannot do anything about it. But apart from this, the only exception to this rule is a proviso mentioned in Article 239 AA, which allowed the LG to refer to the President any issue on which there was a difference of opinion with the Council of Ministers. In such a case, the LG would be bound by the President's decision. Now, this difference of opinion can be related to police, public order and land, but they can be with respect to various matters, and this is where the main problem starts. Since the Lieutenant Governor can have issues in any of the fields under the matters of Legislative Assembly and Council of Ministers, he or she can refer any matter literally to President, which then ultimately will be decided by central government. And so this created a big problem. And so on all the matters where LG and Council of Ministers have differing opinion, neither LG nor COM can decide on their own, but that matter has to be referred to President. And so you can see that this particular judgment did not do anything exceptional to help solve this complicated situation. And that is why the Government of India came up with Amendment to the GNCTD Act 1991, which is known as Amendment Act 2021. And government gave two very specific reasons to come up with these amendments. The government said that there was no structural mechanism within the 1991 Act to ensure time-bound implementation of the rules of the Act. And also, the law gives no clarity about what proposal or matters need to be taken up with the LG before issuing an order. And so there was a time that these two things needed to be clarified. And so this particular amendment brought two important changes to the Act. First, the amendment says that the term government in any law made by the Legislative Assembly shall mean LG. Whereas, if you remember the 2018 judgment of the Supreme Court, it said the LG would be bound by the aid and advice of Council of Ministers in matters that were not directly under the control of LG. And the second important change which the amendment has made is that LG's opinion shall be obtained before the government takes any executive action based on decision taken by the cabinet or any individual minister. So now the LG's opinion has been made must even before the decision has been arrived at, and all the references to the government would mean references to the LG. So indirectly, all the powers are now being transferred to the Lieutenant Governor of Delhi. And that is why the Delhi government has again challenged these amendments in the Supreme Court. Apart from this, there are two other important aspects as well. For example, under the Amended Act, Legislative Assembly shall not make rule to enable itself to its committees to consider the matters of day-to-day administration of the capital or conduct inquiries in relation to the administrative decisions. Any of the rule made in contravention of this provision shall be void. So the Legislative Assembly cannot make any rules And that is a big problem when it comes to the normal functioning of the Legislative Assembly. And finally, the LG will not assent to and pass on to the President for consideration of any bill which incidentally covers any of the matter which falls outside the purview of the power conferred on the Legislative Assembly. Which means that if LG feels that any of the upcoming draft bill has potential to impact either public order or police or land directly or indirectly, he will not give assent to that particular bill. This has now been explicitly mentioned. So now this has created a lot of problems and there are a lot of issues with the Act. First and foremost, centralization of the power in the central government. The Act favors vesting real powers in the nominated LG rather than in the representative government. Then it undermines the representative form of the government. LG, who will now be the government, is under no obligation to implement any law passed by the Assembly or carry out the directions of the House, as he or she is not responsible to the Assembly. Then it also goes against the much touted cooperative federalism principle of the central government. At the same time, it is also going to create a lot of roadblocks for the Delhi government. The elected government of Delhi will have to wait endlessly for the LG's opinion without being able to execute their decision. And hence there are high chances that the government could become dysfunctional in Delhi. And apart from all the facts, the Act has been passed in haste without being referred to select committees and without proper debate.
Next article for discussion, Justice Dinesh Sharma to head the UAPA tribunal related to ban on PFI, appears on national page. So the centre has appointed Justice Dinesh Kumar Sharma of Delhi High Court as the presiding officer of Tribunal for Unlawful Activities related to ban on Popular Front of India and its associates. Now if you look at the GS Paper 2 syllabus, under polity, statutory, regulatory and various quasi-judicial bodies is a part of your syllabus. And so on one hand, you have judiciary, the traditional judiciary headed by Supreme Court at the national level and by High Court at the state level, is now being complemented in adjudication by these tribunals. And so you have proliferation of a lot of tribunals in almost all the fields of governance. And this proliferation of a lot of tribunals is not out of sheer accident. It has been necessitated because of the lack of the judiciary to dispose the number of cases in a timely fashion. Also, because of lack of specialization available with the traditional judiciary, there was a need felt for parallel adjudication of specialized matters. For example, service matters, taxation, matters related to aviation and a lot of other things. And hence came the era of tribunalization. And so we are going to first understand what tribunals are, what was the constitutional amendment which led to the foundations or which led the foundation of tribunals in our country, what are the challenges which tribunals are facing in our country, and what could be the way forward. Let us now begin the discussion.
So tribunals. What are tribunals? So if you have to define them in simple words, you can say that tribunals are judicial or quasi-judicial institutions established by law in India. Now there is a very subtle but important difference between a judiciary or a judicial body and a quasi-judicial body. So a quasi-judicial body is a non-judicial body which can interpret law. And so they are generally in the form of either an arbitration panel or tribunals. So in this case, we are going to discuss the tribunals. Now the obvious question which arises is that when we have such an extensive system of judiciary, we have lower courts, we have high courts and Supreme Court, why do we need a separate set of quasi-judicial bodies? And there are mainly two reasons for that. First is that they intend to provide a platform for faster adjudication as compared to traditional courts. So we already know the kind of pendency we have in our court system, right? So the pendency of cases in courts is one of the key challenges faced by judicial system. As of June 2021, there are around 91,885 cases pending for more than 30 years in different high courts in our country. So now you can imagine that these are the number of cases which have not been disposed for more than 30 years. And we have not taken into account the cases which were filed last year or in last 5 years, 10 years and 20 years. Then in Supreme Court, the situation is no better. There are around 67,000 cases pending in Supreme Court as of 1st of May 2021. And in this regard, the Law Commission of India noted that pendency in court leads to delays in the administration of justice, thereby impacting efficiency of the judicial system. Further, it noted that in certain technical cases, the traditional courts need expert knowledge for adjudication. For example, let's say there is a case of taxation, and we know how complicated taxation is. While of course our traditional judiciary goes through all the laws, but would it not be better if the cases related to taxation were dealt with people who master or are expert at handling these cases? So reinstate the same points which we have discussed. What are tribunals? They are quasi-judicial bodies established by law, which means parliament or the legislature has to establish them. And secondly, why do we need them? We need them to expedite the judicial process in our country, and we need expert advice in some or the more of the cases. And for that, we need tribunals. Now there are two questions which arise. First is that what is the legal or constitutional basis for the establishment of these tribunals? Because when we already have integrated judiciary, establishment of tribunals would definitely conflict with this system of judiciary. And so there has to be a constitutional basis for that. And that is 42nd Amendment Act, which we'll discuss. And the second question which arises is that once these tribunals are established, what is their relationship with the existing traditional system of courts, which has subordinate courts at the bottom and Supreme Court at the top? So all of us know that in 1976, Articles 323A and Article 323B were inserted in the Constitution of India through 42nd Constitutional Amendment. Now these two articles, although established the tribunal system in India, but both of these tribunals are meant for separate purposes. While Article 323A empowered the Parliament to constitute administrative tribunals, while Article 323B specified certain subjects such as taxation and land reforms for which Parliament or the state legislatures may constitute tribunals by enacting a law. Now one thing which you should note over here is that Article 323 provides only for very small number of sets on which tribunals can be provided for. But in India, you have a lot of tribunals, more than 20 to 30 tribunals. And so how is that possible? Now that has been made possible by a 2010 Supreme Court judgment when the Supreme Court clarified that the subject matters under Article 323B are not exclusive. And legislatures are empowered to create tribunals on any subject matters under their purview as specified in the 7th schedule of the Constitution of India. So basically Parliament can make tribunals on all the matters under list 1, and state legislatures of course can make tribunals on all the matters of list 2, and both of them can do the same for list 3. So that is it. Now here from the perspective of prelims examination, two things should be noted over here. First is that Article 323 gives the power to just the Parliament and not to state legislature to set up administrative tribunals. And the Parliament can do that both for centre as well as state. Whereas in the Article 323B, the power has been delegated to both Parliament and legislature as far as it lies in their legislative competence. Now most of the aspirants do not have clarity as to what is the relationship of these tribunals with High Court, Supreme Court and subordinate court and again High Courts. So first things first, there is one Supreme Court which lies above all the courts in our country, and so High Courts are directly under the Supreme Court and our subordinate courts are under the jurisdiction of their own or their state's High Court. That is clear, right? And so currently tribunals have been created both as subordinate to high courts. So there are a lot of tribunals which are located almost at the same level of subordinate courts. And then some of the tribunals have also been created as a substitute to high courts, which means they lie almost at the same level of high courts, or they are parallelly situated as compared to high court. So in this case, the appeals from the decision of the tribunal, for example, Security Appellate Tribunal, lie directly with the Supreme Court. Whereas in the case of tribunals, when they act as a subordinate to High Court, naturally their appeals are heard first by High Court, and when they are further challenged, they go to the Supreme Court. So as far as the arrangement of tribunal in our judicial system is concerned, we have placed them at two locations and not just one. So in this case, substitute to High Court, and in this case, subordinate to High Court. And this is a big problem, because when you are setting up an institution to act as a substitute to High Court or even to a subordinate court, are you able to provide that kind of autonomy, independence to these institutions so that they can act really as a replacement of High Court or even subordinate court? And this is what we are going to discuss later on. And before we move on to the challenges faced by these tribunals or tribunal system in our country, it is very important to trace the evolution of these tribunals in our country in a very succinct manner. And it is not at all important to keep these dates and these recommendations in your mind, but they are going to play a big role in making you understand the tribunal system in our country. So in 1974, Sixth Law Commission recommended setting up a separate high-powered tribunal and commission for adjudication of matters in High Court. And so of course that was aimed at reducing the amount of pendency at the High Courts. Then Swaran Singh Committee in 1976 noted that High Courts were burdened with services cases by public servants, and hence it recommended setting up of administrative tribunals. An All India Appellate Tribunal for matters from labour courts, tribunals for deciding matters related to various sectors, for example revenue, land reforms and essential commodities. And it recommended that decisions of the tribunals should be subject to the scrutiny of Supreme Court. Following the recommendation of the Swaran Singh Committee in 1976, 42nd Constitutional Amendment was passed, and so it empowered the Parliament to constitute administrative tribunals and other tribunals. We have discussed that. Since 1980, several tribunals have been established so far. One of them is Central Administrative Tribunal for Administrative Matters, Security Appellate Tribunal to hear cases against decisions of financial sector regulators, Appellate Tribunal where decisions of Central Film Certification Board could be challenged, and Appellate Tribunal for Electricity to hear tariff issues. And there are many other tribunals. But in 2017, through Finance Act 2017, the tribunal system in our country was reorganized. It was reorganized by merging tribunals based on functional similarity. And so, the number of tribunals was reduced from 26 to 19. And at the same time, the Finance Act 2017 delegated powers to the central government to make rules to provide for the qualification, appointment, removal, conditions of service for chairperson members of tribunals. And then, in 2021, we have Tribunal Reforms, Rationalization and Conditions of Service Bill 2021, because of which we are discussing the whole thing today. As the bill was pending at the end of the session, an ordinance with similar provision was promulgated in April 2021. They abolished 9 tribunals and transferred their functions to existing bodies, judicial bodies, and mainly high courts. And so the main challenges which these tribunals face is right there on your face, on your screen. It is the ability of the government to tweak with their service conditions, the way they are appointed, the way they are removed, the way they are merged, the way they are created and abolished. This is not possible in case of traditional judiciary. The government cannot abolish High Court, Supreme Court, or even the local level of judiciary. And so the obvious question which arises is that when you are transferring such important judicial powers to an authority like a tribunal, are you enabling them with the same kinds of autonomy, independence and powers? You are not. And so whenever we talk about the challenges being faced by the tribunal system in our country, mainly we talk about 2 challenges. First is their quasi-judicial bodies, whether they have the same degree of independence from the executive as the courts that they replace. And the second deals with their success in achieving quicker decisions on disputes. Of course, in addition, their place within the constitutional scheme of our country has been questioned a lot. And Supreme Court has examined some of these issues and has laid out some principles. And let us now start understanding the challenges faced by tribunals by degree of independence that they have. And it is important for these tribunals to be independent because you are transferring the powers of adjudication of High Court to them. And so if they are not independent like High Court, how are they going to function? So what are the parameters on which we are going to judge any institution's independence? Of course, the selection process, its composition, term of office of its members, and administration of its tribunal. Now we understand that total insulation of judiciary from all forms of interference from the executive is a basic essential feature of the constitution, right? And tribunals are quasi-judicial. Now generally what happens in the selection process of these quasi-judicial bodies or tribunals is that there is a panel which selects the members. So for example, the selection committee for appointment as a member of Central Administrative Tribunal consists of one member from judiciary, which is a sitting judge of a Supreme Court who is nominated by Chief Justice of India, and 3 representatives of the Government of India. For example, Secretary to the Government of India, Secretary to the Government of India in Ministry of Law and Justice, and of course Chairman of Central Administrative Tribunal himself or herself. So now you can see that there is 1:3 ratio of judiciary is to executive in the selection committee. And so you can say lack of judicial dominance in the selection committee of tribunal violates the doctrine of separation of powers. And it is actually an encroachment on judicial domain, right? And not to forget that executive is often a party in litigation themselves. Then the next important challenge which the tribunals face is about the composition of the tribunals themselves. We know that tribunals contain both members from judiciary or judicial members as well as expert members or people with technical knowledge, and this is what distinguishes a tribunal from a traditional judiciary where all of the members of a bench are just judges. And so in a lot of tribunals the composition is such that the technical members are in majority whereas the judicial members are in minority. And so when you are transferring a matter from a high court to a tribunal, this is where you breach or dilute the independence of the judiciary. So dominance of executive not just in the selection process but also in the composition of the benches as well. Then the term of office or the conditions of office of members of these quasi-judicial bodies is very, very important. Because if government has power to remove them, to reappoint them, to make them members of other committees, then of course it is going to impinge upon the independence of these tribunals. Now short term or tenure in the office is very, very problematic one. Because by the time members achieve the required knowledge, expertise and efficiency, their term gets over. Further, it discourages meritorious candidates from applying for such positions as they may not leave their well-established careers to serve as a member for a very short period. And so in 2020, Supreme Court stated that the term of office for the chairperson and other members must be 5 years, subject to maximum age limit of 70 years for chairperson and 67 years for other members. We know that the administration of these tribunals are under some or the other ministries. So when the administration of a tribunal is being handled by a ministry, of course it does not bode as well with the independence of that organization. So this is about degree of independence, which has 4 parameters in it. This is a very crucial one and this is the biggest challenge that they face. But the biggest reason for which the tribunals were set up was to expedite the cases or reduce the number of pendency in the High Court and the lower court. So how has been the success of these tribunals in achieving quicker decisions? But as it turns out, a lot of tribunals are facing the same issue of backlog of massive number of cases. So for example, Central Administrative Tribunal still has around 45,000 cases pending. 90,000 cases are pending in Customs, Excise, Service Tax Appellate Tribunal. Income Tax Tribunal has around 90,000 cases and more than 10,000 cases in Armed Forces Tribunal. And similar is the case with most other tribunals as well. And so if you compile all this data together, it is almost at the same level of that of traditional judiciary. And so the people start asking questions, how good or what is the benefit we are deriving out of these tribunals? They are neither independent nor are they doing their work faster than the traditional court. And of course the biggest reason behind this pendency still continuing in tribunals is the lack of human resources, because they don't have adequate number of judges. If they have sufficient number of judges, they don't have staff to support them. And then finally comes the matter of constitutional scheme. Where do they actually fit in and how are they justified? Because the constitutional standing of tribunals has been questioned. In particular, whether the jurisdiction of high courts and Supreme Courts can be removed at all. So in 1986, Supreme Court ruled that Parliament may create an alternative to high courts provided that they have same efficacy as high courts. So you can transfer them some powers, they can replace high courts, but they need to have the same level of autonomy and independence as that of high courts. But Supreme Court made an important observation. Supreme Court stated that tribunals must not adjudicate on questions related to the constitutionality of their parent statutes. So, for example, if there is an income tax tribunal, they can interpret and discuss various cases, adjudicate on various matters based on IT Act, but the tribunal cannot question the constitutional validity of the Act itself. So this is what Supreme Court has said regarding the tribunals, and this is also one of the challenges because simply they do not have the same level of efficacy as that of traditional judicial system. So what about the Tribunals Reforms Bill? What are the provisions of this bill? So the first provision is that it transfers functions of key appellate bodies from appellate bodies to either the high courts or to another existing tribunal. For example, Cinematography Act has appellate tribunal which now has been transferred to High Court if this bill passes. Similarly, Appellate Board for Copyright Act has been transferred to Commercial Court or the Commercial Court Division of High Courts. And similarly, you can see that there is a lot of rationalization which has been done with respect to a lot of tribunals existing. Then, as we have discussed, that Finance Act 2017 did a lot of changes. It empowered the central government to notify rules on composition of search cum selection committee, qualification of tribunal members, their terms and service condition. Now the bill removes these provisions from the Finance Act. Then as far as search selection committee is concerned, it will consist of Chief Justice of India or a Supreme Court judge appointed by him, two secretaries nominated by central government, sitting or ongoing chairperson, or a retired Supreme Court judge or a Chief Justice of High Court, secretary of the ministry under which the tribunal is constituted. And similar is the case with the state tribunals as well. And finally, as far as term of office is concerned, the bill provides for 4-year term of office subject to the upper age of 70 for chairperson and 60 for other members. So these are the provisions which are being brought by the new bill. Now you have to let us know in the comment section whether these provisions, if implemented and passed by the parliament, are going to enhance the independence of tribunals or not. Let us now move on to the next discussion.
There is an article on page number 11. Is India in a bind over its relations with Russia? This article discusses the dynamics in the geostrategic relation between India, Russia and China. Of course, US will have its fair role to play in deciding this dynamics. Presently, India is at inflection point in geopolitical strategy. After the confrontation with China along LAC, India is moving closer to West. To say in the geopolitical parlance, India is moving westward. But India has always maintained that India will never compromise on strategic autonomy. India will never be part of any military or political alliance. So India has always balanced its alignment with West and Asian power. For example, India participated in Quad, that was started after the tsunami of 2004. But India also participated in groups like RIC, then BRICS, then SCO. But this balance sometimes seems difficult. And after the recent border confrontation, there is opinion in many quarters that India should more actively participate in the geopolitical groupings led by US. India has called to strengthen Quad 2.0. Quad began around 2004-05. Then it was dismantled in 2008. Then it was formed again, dubbed as Quad 2.0 in 2017. But since 2017, there is a request from Australia pending to participate in the Malabar exercise. And India has not taken a decision on this yet. Malabar exercise basically is seen as a theatre for cooperation of the Quad grouping. Malabar exercise began initially as a bilateral exercise between India and US. Later, Japan and Singapore also started participating. Then Australia too joined it. But due to stiff opposition from China, and US needed China around 2008 to get North Korea on table for talks. So US gave in into the demand of China, and this whole thing was wrapped up in 2008. So Australia stopped participating in the Malabar exercise, but Japan continued later on from 2015. Now many officials in External Affairs Ministry wants Australia to be readmitted into Malabar exercise. Also in the recent virtual summit between India and Australia, India signed a new military logistic agreement with Australia. And a similar agreement is expected to be signed between India and Japan. So there are many signs of India shifting westward. But however, the External Affairs Minister S. Jaishankar has clarified that India will never be a part of any alliance. In the past, China and Russia has declared this Quad grouping as a form of Asian NATO. So if India gets too engaged in Quad 2.0 without adequate upscaling of relationship with Russia, then obviously India will be seen to be getting aligned with the Western powers, specifically US. But if we continue to participate in BRIC, that will serve the purpose of showing that India has a strategic independence, and apart from that, there will be an obvious benefit that India can draw from all the major power in the region. See, after disintegration of USSR, Russia was looking for a regional grouping, and talks were going on since early 90s for such a regional grouping, but it could materialize only in early 2000, and hence came into being the grouping called as RIC, Russia, India and China. This was done as a preparation for transition from unipolar to multipolar world, and all three countries did not want the world to be unipolar, all the powers being concentrated in US. However, this grouping never projected itself as anti-US. Rather, all three countries had very good relation with US in the beginning. Relation with Russia was manageable until 2014 when Russia annexed Crimea. Until Obama administration, relation with China was also good. Relation with India continues to be good. The cohesion among the three countries in the grouping were on the issue of territorial integrity for social policies and opposition to regime changes from abroad, which was an ever-persisting threat from US for Russia and China, not for India. The objective of the group expanded further into global economic and financial architecture. They wanted democratization of global economics, basically targeting World Bank and IMF. And this brought into board Brazil, so RIC became BRIC. And then South Africa will come too, that will make the grouping as BRICS. With the formation of BRICS Bank or the New Development Bank, this idea of democratization of global economic and financial architecture will come to its final logical conclusion. If you see purely from India's perspective, RIC has borne a lot of fruits for India. The bilateral relationship between India and Russia and India and China improved in the initial years of the RIC. With Russia, it continues to improve. With China, the improvement stalled after India went very close to US in 2005 and 6. The bilateral relationship between India and Russia improved on the political front, in defense, in energy, in all the major geostrategic pillars. The Russians have always backed India on the Kashmir issue. There was joint development of BrahMos missile system. Also, there was joint development of 5th generation fighter aircraft and multi-transport aircraft. The progress has been made for licensed production in India of Su-30 aircraft and T-90 tanks of Russia. India has procured INS Vikramaditya from Russia, and this INS Vikramaditya is acting as the aircraft carrier of India. INS Vikramaditya is the only aircraft carrier with India. True or false? India and Russia is also jointly building a nuclear power plant in Bangladesh. You must also be aware of the sale of 98% stake of SR Oil to Rosneft. Rosneft is the state-owned oil giant of Russia. This shows the confidence of both the nation in each other. So if you see the trajectory, relationship with Russia kept on improving, but it somewhere got plateaued. If you see from 2000, relationship with Russia has improved. But after 2014-15, after the Crimean annexation, relationship started plateauing. When India diversified its defense procurement with US, Russia went towards Pakistan. Russia saw Pakistan as a good market to sell its defense procurement. Russia also needed Pakistan because Russia was adventuring into Afghanistan. The trajectory with China is very different. Although in the initial years of RIC, the relationship with China improved. It improved till 2005, and after that it got plateaued. And after that the relationship kept on deteriorating, and it has deteriorated to the lowest in the present time. In 2003, India and China decided to bring a political approach to the boundary dispute. And in 2005, there was identified some political parameters. that will be applicable in the eventful border settlement. Meaning, whenever we will get on tables for border talk, there will be some political parameters that will be considered by both sides. And this implicitly recognized India's interest in Arunachal Pradesh, because these political parameters included strategic and reasonable interest of both the nations, and any border talk should safeguard due interest of their settled population in the border areas. But however, by this time, India got very close to US and India was in talk with US for a civil nuclear deal. Financial meltdown in 2008 happened, and that gave an opportunity to China to emerge out as a financial powerhouse at global level. After that, the relation between US and China will start to deteriorate and China will become more assertive. And China will violate this agreement of 2005. So as there was upswing in the Indo-US relation, there was downswing in India's relation with Russia and China. The slope of the downswing was higher, much higher for China. India improved its relation with US. There was surge in trade and investment. There was a landmark civil nuclear deal and a burgeoning defense relationship. India's objective was to diversify its military acquisition away from total dependence on Russia. And as we have seen that after 2008, China will be expanding its muscle at the global arena. US saw this very early, and US saw the value in partnering with democratic India in Asia. This has been mentioned by various US Secretary of States, and they have written in their books that it was their intention to develop warm relationship with India. However, India also saw interest in developing relationship with US. On the downside, China went back on the 2005 agreement for settling the border issue. China launched China-Pakistan Economic Corridor. This was launched in 2013, but the talk for this started much early. China expanded its military and economic presence in the Indian Ocean and desperately wanted to undermine India's influence in the neighborhood. The result of this you are seeing today. Sri Lanka, Maldives, Nepal, and now Bangladesh. Also in yesterday's newspaper, you must have read that this China-Pakistan Economic Corridor, now they are planning to extend till Afghanistan. And recently there was a conference between China, Pakistan and Afghanistan. There they discussed this issue. Not only Afghanistan, a branch of this, they want to stretch to Nepal. Similarly, 2004 was the inflection point for the US-Russia relationship after the Crimean annexation of Russia. US imposed sanctions and Russia's pushback against US included, among many things, cultivating Taliban in Afghanistan. Russia is also very active in the Afghan peace process presently. To cultivate Taliban, Russia naturally needed the support of Pakistan. Russia also did military drills with Pakistan. Russia gave many defense equipment to Pakistan, over which India has raised flags many times. Also, the Western campaign to isolate Russia drove it much closer to China. Surprisingly much closer than what one would expect from their historical ties. Historically, Russia and China had border issue. Relationship was not very warm, never. But US desperate attempt to isolate Russia brought Russia and China very close. Now Russia does not see China as threat the way India sees it. So if we want to roughly graph this thing out, it would look like this. From 2005, relationship with US improved. It improved and we have come to 2020. This is an inflection point. Either we can maintain the same trajectory or we can speed up our improvement and go much closer to US. We can go on path 1, we can go on path 2. This is a graph for Indo-US relation. With Russia, obviously we'll start with a higher base. India shared stronger relation with Russia than US. Relationship further improved and it got plateaued by 2015. Now we are at inflection point with Russia and China as well in RIC and in other groupings like SCO and BRICS. If we go on path 2, then obviously relation with Russia and China will take a dip. This will be the path 2 corresponding to the path 2 of US. Or if we improve our relation with Russia, then the relation with US will suffer. But the problem is, if we improve our relationship with Russia, we have to engage in groupings like RIC, SCO, BRICS, where there is presence of China as well. and there is no possibility of developing a very cohesive relationship with China. So what we can do is we can improve our relationship with Russia and maintain a manageable relationship with China, so that overall the relationship with RIC, SCO, BRICS grouping like this improves. And relationship with West, the US through the groupings like Quad, that also improves. So we benefit from both these blocks, so that it does not turn out to be a zero-sum game for us. Not going very close to any one of them, maintaining our strategic autonomy will be in the best interest of India. The question that has to be asked is this: if we are not going close to Quad or other US-based grouping, then what benefit can we draw by staying away from US and increasing our engagement with Russia and China? Well, there are many benefits as per the author, and I have added few more. The author says that Shanghai Cooperation Organization is centered on Russia and China. So is BRICS. But Shanghai Cooperation Organization is of special interest for India because it includes Central Asian countries. India has a special interest in Central Asian countries. India also has historic ties with these nations, right from the period of Indus Valley civilization. India also has an air base there. India has a detailed strategic planning to reach to Central Asian nation via Iran, Chabahar port, the onward rail link, the international north-south transport corridor. All of them are the plan of reaching out to Central Asian nations and from there up till Europe. So because Central Asian nation is there in SCO and there are possibility of Iran and Afghanistan getting admitted as member, right now they are observers. But China is in the process of getting into 25-year agreement with Iran. China and Russia also have a special interest in Afghanistan. We just now discussed that China is now considering extending the China-Pakistan economic corridor till Afghanistan. Russia also has a strategic interest in Afghanistan. So possibility is very high that Iran and Afghanistan in near future will be admitted as full-fledged member in SCO. India's interest in Iran cannot be stressed more. India has developed Chabahar port there. India is one of the highest buyer of Iranian oil. India is considering manufacturing fertilizer in Iran and then exporting it from there to elsewhere. Iran forms the gateway for entry to Afghanistan bypassing Pakistan. Iran also forms the gateway for entering to other Central Asian nations. So if Iran and Afghanistan and Central Asian nations are there in a group, India must be there. And India cannot be an active participant without cooperation from Russia and without having a manageable relationship with China. Further, it is also important to shape the China-Russia dynamics, the hegemony that Russia has in this region, and the greater influence that China now is showing in the region. The Central Asian countries have signaled that they would welcome some dilution of the China-Russia, Russia-China duopoly. The Central Asian nations are ready for a greater engagement of India in the region. And the appropriate forum for India to increase the engagement is SCO. RIC is not only the core of SCO, RIC is also the core of BRICS. India also have to seek the cooperation of Russia because India started this international north-south transport corridor in cooperation with Russia and Iran. And for this to branch to other Central Asian nations, extreme cooperation is required of Iran and Russia. Russia's abundant natural resource is also of interest for India, especially their natural gas. While protecting our interest on border and our sovereignty, we have to cooperate with China on many issues, on technology and even in economy. The bilateral trade between India and China has grown to such an extent that any snapping of ties will prove to be debilitating for Indian economy. What's very important thing about RIC is that Russia is trusted both by India and China. And it's always good to have a mediator between two tussling power. In fact, RIC was the first forum in which India and China had talked after the Doklam standoff. Further, if India goes close to US and start to actively participate in groupings like Quad and J, which is an acronym for Japan, America and India. The problem with this is Japan or US or Australia, they do not have land border with India. And the interest of these nations revolve around Indo-Pacific. The cooperation, the military exercises, the drill mostly is maritime in nature. But India's aspiration is not just to be a maritime power, but both maritime and continental power. None of the nation is likely to intervene directly in case of a land conflict between India and China. What is most important that you must remember is India or any other nation for that matter cannot outsource national security. We will have to manage our national security ourselves. We'll have to be Atmanirbhar in this case. And for that to happen, cooperation with Russia is quintessential. And maintaining a manageable relationship with China is also very important. Cooperation between India and China is very less likely. The two nations are competitors. But what we can do is we can take Russia in confidence and keep cooperating with US. If we do these two things, then China will be managed. We can increase our economic links with Russia. India participated in 2019 in the Eastern Economic Forum, and Prime Minister Modi called for a Look Far East policy. If India can take this Look Far East policy further and develop strong economic links with Russia, then the relationship will be taken to an extent that will come above suspicion and surely survive minor frictions. The concept of Chennai-Vladivostok Maritime Corridor has been developed. This maritime corridor must be activated, and once this is activated, the trade ties between India and Russia will become very strong. And we may persuade the Russians that its interests in the Pacific are compatible with our interest in diluting the Chinese dominance in the region. And this will accord well with the President Putin's concept of Greater Eurasia. President Putin has developed a concept called as Greater Eurasia that will include more nations in the Eurasian Economic Union. This basically is considered as a romantic concept. Russians are going 100 years back when they were very powerful, fantasizing about more hegemony in the region. This has not been kick-started to a considerable extent, but Russians still hold this as an important concept in their geopolitical strategy. So if we can show that this concept of Russia can be taken forward only after diluting the Chinese dominance in the region, that will do the job. So going close to Russia and also to US seems to be a viable way of countering China. But going too close to any one of them will be counterproductive. Because geopolitical dynamics take turns many times. It took turn in 2008. China started to appear at the global stage. It took another turn in 2014, where relation of Russia and US came to a new low, and that affected the relation of India and Russia as well. The third point of inflection can come after COVID-19. We do not know in what shape US will come out of it. US has pulled out of Quad in 2008. US can do it again. Relying too much on any power will not be wise. National security cannot be fully outsourced. There are nations who have done it like Saudi Arabia, and we have known what price they have paid. India has to be Atmanirbhar in this regard.
There is an article on page number 12 on gig economy.
Gig economy, as you would understand, refers to a form of economy in which organizations employ only contractual non-permanent employees instead of permanent employees. This is one of the basic fundamental definition of gig economy. The gig economy workers, however, can range across the spectrum of profession, from highly paid to below minimum wage. And this especially is true for advanced Western countries, where the firms hire contractual workers on short-term basis. For example, when the establishment of factory is in the project phase, in the initial phase, they can hire very skillful architect. They can also hire some environmental law expert. But once they have the license, when they have the building up and running, they can dispense off these experts. Gig economy in India is poised to dominate in the coming years. The gig economy can serve up to 90 million jobs, which accounts for roughly 30% of India's non-farm workforce. This estimation is for the year of 2025. There's one crucial difference in normal employment and employment under gig economy. In case of ordinary employer-employee relationship, the employer can dictate as to when, where, and how the work is to be carried out. But in gig economy, workers have complete control over these aspects, of course subjected to the larger, broader terms of contract. Workers have greater autonomy over the work. They have to just yield result, complete the work in the stipulated time. But the flexibility is more. That's only one reason as to why gig economy is growing.
But the reason why it is becoming very popular in developing countries, especially in India, is largely because of rapid growth in the digital communication. Advancement and more coverage in digital communication has allowed the workforce to become highly mobile. They can work from anywhere without any hindrance from the geographical barriers. Gig economy also reduces the operating cost of the firm because the companies are not liable to pay pension and any other social security benefits. Workers, of course, have flexibility. They can switch job very easily. There is no notice period. They can choose the work according to their skill and their likings. There's also a push factor for the development of gig economy. There has been recent slowdown in the formal employment creation because of COVID-19, but it did happen even before the COVID pandemic broke. Gig economy is poised to develop in the coming years, and it will dominate the economy in the next decade. So the government also has woken up to the reality of existence and dominance of gig economy. The Code on Social Security 2020, it provides for the registration of all the gig workers and all the gig platforms. It calls upon the central and the state governments to formulate schemes to ensure social security benefits such as insurance for the gig workers. It also empowers the government to set up social security fund for the benefit of gig workers. The contribution to these funds may come from the center, state, and the aggregator platforms. But nothing much has happened on this concept that is provisioned in the Code of Social Security 2020. There are many concerns regarding the rights of gig workers. First of all, there is no guaranteed benefit to gig workers. The industrial workers are automatically guaranteed social security benefits, such as Provident Fund, insurance, even maternity benefits. However, such benefits are not automatically extended to gig workers. The central and the state governments are required to come up with schemes to provide for these benefits. So the social security benefits for gig workers depend upon the political will of the government. Because of the informal nature, there is no guaranteed benefit automatically, and also there is no guaranteed contribution from the aggregator. The Code on Social Security that we just talked about mandates the industries employing workers above a certain threshold to compulsorily contribute towards social security benefits like Provident Fund and insurance. However, as far as gig workers are concerned, the language of the code does not provide for such compulsory contribution by the aggregators. Hence, it is left open to the government whether to seek contribution from the aggregator platforms or not. So it's not a matter of right that the aggregators must contribute for the social security of the workers. Similarly, the industrial workers are given legal rights over the various aspects of workers, such as payment of minimum wage, safe working condition, or the right to strike, right to form trade unions, etc. All these are legal rights. However, such rights are not recognized in case of gig workers. There are also absence of some labor rights. For example, the gig workers may be asked to wear a particular kind of uniforms. They may not also choose the order of their task. For example, you must be very familiar with the idea that the Zomato, Swiggy delivery partners or the Uber Ola drivers, they do not choose the ride. It is allotted to them. But then it is true that the work that you do in formal employment is also allotted to you by the superiors. It is often said that the gig workers enjoy a high level of freedom and flexibility in their work. However, these advantages gets overshadowed by their higher dependence on the platform. The control of the platform on the workers, the employees, is very high. For instance, if a person wants to work as a cab driver or a food delivery partner, he needs to own a vehicle. Since poor people do not have access to loans, they come to be dependent on the platforms for the loans provided by them. This in turn reduces the flexibility associated with the gig economy. The workers would have to work according to the needs and requirements of the platform companies then. So if you have to talk about the rights of gig workers, you can categorize the rights according to this and structure your answer properly.
The next article has appeared again on national page, and it deals with a very important defense equipment, which is HAL Prachand. Designed, developed and extensively tested by Hindustan Aeronautics Limited, the multi-role attack helicopter has been customized as per the requirement of the Indian Armed Forces to operate both in desert terrains and high altitude sectors. The LCH is the only attack helicopter in the world that can land and take off at an altitude of 5,000 meters, which makes it ideal to operate in the high altitude areas of Siachen Glacier. It is also capable of firing a range of air to ground and air to air missiles that can destroy air defense operations of the enemy. So, if we look at all the features, you can clearly see that it has helmet mount display system, turret gun, electro-optical pod, air-to-air missile, rocket pod, and solid-state digital video recorders. Now, all these features are not worth remembering. What you have to remember that it can fire air-to-air and air-to-ground missile. It is completely indigenous and it is multi-role attack helicopter, which means it can take a lot of roles while in war situation. The last article for today is about Nobel Prize in Literature. So, Stockholm French author Annie Ernaux, known for her deceptively simple novels drawing on personal experience of class and gender, has been awarded Nobel Prize in Literature. Her more than 20 books, many of which have been school texts in France for decades, offer one of the most subtle, insightful windows into the social life of modern France.